and the facts that this case is about. Before, it is important to remember that the Russian Union became a union of different states, which are the Republic of Bobia, the Kingdom of Kasalia, the Commonwealth of Tingoth, and the State of Ephraim. This was composed by contiguous and developed states, economically developed states. The Russian Union was formed to promote economic growth, cooperation, closer political unity within the Union. A treaty was established. The Treaty of the Russian Union provided 4 organs. These organs were the Parliament, that was elected directly by citizens of these member states, the Council, composed by 1 representative of each of the governments of the member states, a Commission, which were a president plus 4 ministers, and the High Court. Respondents intended the Russian Union to constitute a new legal order in international law. That is why they furnished the Union, meaning that they gave the faculty to the Union of having great deal of autonomy to enact or to make into an act or statute legislation seeking to further the objectives of the Union. Okay, moreover, 25 years from these developments, they established common policies for all member states. They even supplanted domestic laws in numerous economic aspects. The High Court also actively brought offending states to task for not enacting common legislation. This was how the Russian Union started to act as harmonizer of economic growth between states and as representatives of member states in dealing with non-members. As of this, in 1991, respondents signed a convention amending the Russian Union Treaty, that was the CARUT, to, in this matter, empower the Union into coordinating of non-trade relations between respondents and non-member states. The currency of each state was replaced by a single Russian currency, that was the ruble. Relations of non-member states have grown considerably. For example, the Russian Union negotiated mutual judgment recognition treaties with the United States of America in 1995 and India. The Russian Union also became a party to the WTO, which was the World Trade Organization, in its own right. It is important to highlight the fact that the WTO is the organ that deals with the global rules of trade between nations, easing the process. In 2004, the President of the Commission successfully negotiated for the release of hostages that were nationals of member states held by a paramilitary organization. In addition, the Republic of Bulgaria, being the applicants, applied for the Russian Union membership. Neighboring countries. It was a neighboring country constituted by a majority of Adarians and a minority of Sofians, which had own cultural and religious heritage. Reviewed their application, the Commission determined they were suitable if they achieved four recommendations that the Russian Union gave them, which were to reduce public debt with non-RU members, non-Russian Union members, to privatize state-owned monopolies, to eliminate government support payments to small privately owned businesses, which were recommendations ratified in the AAA, which was the Adarian Accession Agreement ratified by the Council in 2000, and if it met those conditions, it will be eligible for admission. Furthermore, the treaty provided for the establishment of an Russian Union legation in Adaria. A legation means a diplomatic minister and a staff in a foreign mission. The treaty also provided the rights, the privileges, and immunities that would be based on international law. In accordance with this, in 2002, the Russian Union opened a permanent legation in Adaria, led by Yuri, an experienced diplomat that was then welcomed by the Adarian Prime Minister, receiving him and his staff as the representative of the Russian Union in Adaria. Even though the AAA received much popular support in the area as the government took steps into action to meet the obligations or requirements. Support started to vanish considerably. Steps were to increasing taxes, which equals pay off national debts, privatization of state-owned industries through public auctions that were purchased by companies which bases were in the Russian Union, causing inevitable layoffs. Layoffs means dismissals or suspensions of Adarian employees, since they respected their infrastructure. This also modernized pricing so as to charge all consumers the same rate. The Adarian government also established a distinct stage of development to support payments to small businesses that forced many Sofians out of business. In 2003, government announced massive public works program to provide employment to these Sofians, even though the Adarian government was well aware that these employments was not suitable for Sofians. They had prohibition to this because of their religion. That means that the increasing of more measures in the Adarian Accord increased the satisfaction of the Adarian people. Finally, in 2005, the Commission President reported to the Council that Adaria met the obligations. But it is of utmost importance the fact that this accomplishment impeded, particularly, the Sofians from their personal opportunities of survival. Adarians failed to take care of the Sofians as their own citizens. The concern is that a country left its own citizens without water, electricity, jobs, and this would not live up to the Russian Union standards. The admission was postponed until Adaria demonstrates their willingness and ability to care for their people. Announcements were not well received. A wave of retaliation swept through Adaria. For example, Juri was arrested for making illegal political donations. Without the Russian Union's consent, armed agents also entered the legislation and took him into custody. The Russian Union protested this action as a violation of the legation's diplomatic status. More armed agents stormed into the legation to seize meaning forcibly or suddenly to take hold of bank records and computer disks without the Russian Union consent, and to prove a crime that the Adarian Attorney General has not even yet presented formal charges against any Russian Union personnel. Adarian's moves were based on the Adarian Parliament that passed the National Industry Act to prohibit Russian Union owners of formerly state-owned enterprises from transferring profits from Adaria to the outside of the country. The Russian Union's moves were based on one of these Russian Union companies brought a lawsuit in a civil court in Adaria, alleging that expropriation of his or her property, where the court indifferently rejected, concluding that no expropriation occurred. They appealed, and the Supreme Court in Adaria supported and defended the ruling. The important thing was that respondents have decided to act through a common counsel in this case, to promote judicial efficiency. The applicants alleged that respondents violated international law by denying the admission of Adaria in the Russian Union.
Establish the four respondents' requests that we have here. First of all, Adaria's application to join the Russian Union did not breach any international legal obligation owed by the respondents to Adaria. Second of all, may properly bring a claim for the application actions with respect to the Russian Union legation that has to be with Ambassador Hip. Third, violated international law concerning the immunity of diplomatic missions by seizing the premises, property, and personnel of the Russian Union legation. And last but not least, Adarian National Industry Act, also known as NIA, constitutes an illegal expropriation of Adarmore and the other privatized concerns under international law. Here, we're gonna explain some points, such as if the International Court of Justice is competent for resolving this case, What does the AAA means? If the claim against the Daria for its violation of the Russian Union legations right is accord to the function immunity into other points. Okay, about our first respondent's request, that respondents have not reached any international legal obligation when they rejected Daria's membership to the Russian Union. First, we have to establish if the court is competent to resolve this dispute because it is based on in a non-justiciable political question. Okay. The International Court of Justice, can only decide upon legal disputes between states. What are legal disputes? Are the ones that can be obtained from principles and rules from international law. Also, the ones that have no political considerations. Okay, states create international organizations to certain functions. So the decision to admit another state into an organization is based on a political exam or a political evaluation. In this case, the Russian Union has done to the Adarian state to see if the entrance of this state to this union is favorable to those objectives they planned in the beginning of this organization, this international organization referred to the Russian Union. Also, we have to talk about the Article 4 of the UN Charter that says that the admission of any states is by the decision of the General Assembly, but they have to listen to the suggestion of the Security Council. This is a little bit different from the Russian Union because the UN looks up to universal membership. The Russian Union has a different criteria, and the admission of new members is referred to their policies. The Treaty of the Russian Union vests the Commission to establish the admission criteria for the new member states, or for the possible new member states. But the Council is vested with the last word. They review if that criteria was accomplished, was satisfied, etc. Okay. Now, in the case that the applicant's claim was justiciable, the Russian Union didn't violate any legal obligation when it exercised its discretion to admit or not a Daria. Okay, if there was an obligation, it had to exist in the AAA or in any customary international law. The AAA does not obligate the Russian Union to admit a Daria to membership because the Council has the final discretion. The AAA only guarantees that the Daria state is eligible for the admission to the Russian Union. They set 3 conditions. These 3 conditions had to be timely accomplished so the Adarian state can be eligible for the admission. Why? Because these 3 conditions were established by the Commission, but the Council is the one that reviews all the other matters for the Adarian state being a membership. So after they've satisfied the conditions, the Council, the attention of the Council was called because of the Sofians' situation. So the fulfillment of the conditions was necessary for the acceptance of the procedure for the admission to the Russian Union. But it was denied because of the living conditions of the Sofians. So what the organizations or what the Russian unions are looking up to? It is to the applicant's ability to advance the unique purposes and goals of the organization. When the Russian Union was formed, it was to ensure the development and prosperity in accordance with the principles of the UN Charter. And what are these principles of the UN Charter? Is respecting the human rights, the rights of women, and the rights of minorities. And we can see that these were not respected for the Sofians because Daria failed in its treatment, because the Sofians they had not water, they had not power, and no economic opportunities. So this was a question for the Council to accept or not Daria. So the denial of Adaria's membership was consistent to the AAA obligations, the three conditions that were established. Also, we have to say that it was hereby denied. What is that? That if Adaria solved this situation with the Sofian, the Council and the Commission and the Russian Union in general could review again this case and see and take into consideration if the Adarian state could be a membership of this political and economical union. Also, about the first request that we have, the Russian Union didn't violate any rule of customary international law in its treatment to Adaria's application for the Russian Union membership. There is no customary law that requires the admission of Adaria. The admission to an international organization is referred to a political evaluation that the Union does to the possible member state, and it is not ruled by customary law. It is regarded to the constitution of this international organization and the practice of each organization. Adaria cannot bring this custom for the acceptance because each organization is different, because each organization has a different policy. There is no automatic right in law to be admitted to an international organization even if the state satisfied the conditions of an accession agreement. That was what happened with Adaria. They satisfied timely the three conditions, but we need more. And the council is the one that it's going to have the last word, and in this case, they denied their entrance. States are, okay. The first point is that states are not responsible for any international wrongful act that the Russian Union may have committed. So, respondents are not directly responsible for the Russian Union's activity or matters because the Russian Union assumes obligations independently from respondents because they have separate international legal personality. Under international law, international organizations possesses separate legal personalities and are independent responsible for their own acts. The non-member states must recognize this personality. The Russian Union possesses this different legal personality, and this is evidenced in the fact that the Russian Union has entered into treaties with some states. This is the case of the AAA, that was the treaty that celebrated the Russian Union and the Adarian government, also with the World Trade. Adaria has done so by entered in a treaty with them, as we can see. Also, the Vienna Convention on the law of treaties between states and international organizations, in this case Adaria and the respondents are part of, provides that such treaties does not create either rights or obligations for other states and organizations without the consent of that state or organization. The AAA was a treaty between Adaria and the Russian Union, but not for the respondents. The respondents are not responsible for the actions of the Russian Union, and they assume the obligation of the AAA. Okay, about our second respondent's request, that is, that may properly bring a claim for the application actions with respect to the Russian Union legation, we have to establish first what is an international organization. It is a permanent association of states or other organizations with lawful objects equipped with organs. In terms of legal power and purposes between the organization and its member states, there has to be distinctions. We do have international personality. International organizations require a minimum standards, and they are based on three characteristics. First of all, the contrast to diplomatic immunity, it is normal for officials of an organization to have free national of member states, including the host state. It will be only extended in diplomatic immunity on a narrow and highly conditioned basis. Second of all, a diplomat, although immune from the jurisdiction of receiving state, remains under the standing of the jurisdiction. And last but not least, in third point, reciprocity provides an incentive for states to respect international diplomatic law. an international organization does not have access to an effective regime of sanction. Okay, so here what we have to say is about the respondents. Anyway, they delegated some sovereignty to some aspects to the Russian Union, they still have the right to assert claims to the Russian Union. This is the principle of institutional law of international organizations, that international organizations are competent to act only as far as powers have been attributed to some by the member states. Okay, the respondents as Russian Union member states have direct interest in the enforcement of legal obligations owed to the Russian Union. Member states of international organizations have a legal interest in the enforcement of obligations owed to the organizations by other states. Also, the Russian Union represents the political and economical unity of respondents. The court, in other cases, they were deciding reason that the members of an international organization have a legal right and interest in the matters that referred to them. Members of the Russian Union have legal interest in a various respect for the immunity guaranteed that the Russian Union legation under the AAA, also under international law. Okay, respondents have also suffered moral injury as a result of a direct violation of the Russian Union's legation immunity. Okay, what means moral injury? Moral injury means the situation when a state suffers, another state fails to give it due to respect as a co-equal sovereign. One of the primary ways in which a state suffers moral injury is through wrongs to diplomatic missions and like. A direct failure to accord the Russian Union legation immunity violates its obligation to respect the co-equal sovereignty of respondents. It also means the violation of an obligation towards the national state in respect of its nationals.
Okay, it is important to understand that the Russian Union legation has functional immunity under both the AAA and the customary functional law. Adaria agreed to accord privileges of the functional immunity as provided in international law. Under the AAA, the Adarians recognized that it were obligated to afford the Russian Union legation such immunity when they accepted the diplomatic credentials of Ambassador Hip and the other Russian Union diplomatic personnel. As international law generally requires respect for the premises, property, and personnel on international organizations, the AAA should be read to incorporate those immunities. Apart from that, Adaria is obliged to afford the Russian Union legation functional immunity as a matter of custom. In the reparations case, this court found that international law grants international organization immunity for the purpose of ensuring the ability to perform the functions entrusted to them by states. In the United Nations Privileges and Immunities case, the court also acknowledged that states may not establish an organization and fail to provide it with the basic immunities that ensure its independence from its host state. Likewise, in Brano versus Ministry of War, the Italian Court of Cassation held that, even absent conventional provisions, there exists a custom that protects the functional immunity of international organizations. The court reaffirmed this principle in Food and Agriculture Organization versus Colagrossi, expressly stating that customary international law governs the immunity of international organizations. Similarly, the Swiss Labor Court versus Permanent Delegation of the League of Arab States to United Nations held that customary international law recognizes that international organizations, whether universal or regional, enjoy absolute jurisdiction immunity. They explained that this privilege arises from the purposes and functions assigned to international organizations, as they can only carry out their tasks if they are beyond the censure of national courts. The Russian Union legation thus had a right to functional immunity under customary international law. The Russian Union's right to functional immunity required Adaria to respect the inviolability of the legation's premises, property, and personnel. The protection of premises, property, and personnel is universally recognized as necessary for an international organization's independent exercise of its functions and responsibilities. For example, the American Restatement of the Law of Foreign Relations provided that an international organization enjoys immunity from any exercise of jurisdiction by a member state that would interfere with official use by the organization of its premises, archives, documents, or communications. This same immunity extends to officials as well. Likewise, nearly all constituent treaties of international financial organizations, as well as a Convention on the Privileges and Immunities of the United Nations and the Convention on Privileges and Immunities of the Specialized Agencies, specifically provide for the protection of premises, property, and personnel. The UN Convention and the Specialized Agencies Convention are so widely ratified that they are considered to embody customary international law regarding functional immunity. The United Nations Convention, the Specialized Agencies Convention, as well as other treaties, provide that the property and assets of the organization shall be immune from all forms of judicial process. Moreover, they also state that the archives and documents held shall be inviolable wherever located, to ensure the confidentiality and the organization's operations. The United Nations also provides that the premises should be inviolable. While there are no equivalent express provisions in other conventions or constituent treaties, protection of premises can be inferred from their various provisions regarding the protection of property. Specifically, these provisions on searches and confiscations of property demonstrate that the premises of the organizations are outside the reach of states. These conventions provide that the officials of international organizations shall be immune from legal process. This allows officials of such organizations to fulfill their duties without fear of persecution from the host state. It is of utmost importance to understand that the Russian Union legation did not waive its immunity, as its actions were both lawful and within its functions. In the FAO versus INDPAI, the Italian Court of Cassation concluded that the test for determining whether an act was within the functional immunity of an organization is whether the purpose of the activity is directly connected with the institution's aims normally pursued by the organization. As agreed to by Adaria in the AAA, the Russian Union legation was to aid in the diplomatic and economic aspects of Adarian integration into the Russian Union. In assisting states in the accession process, international organizations often provide financial support to pro-integration forces. For example, the European Union, through its FAIR program, has consistently provided financial aid to less economically developed European countries which seek admission to the European Union. Like the FAIR program, the Russian Union legation's contributions to pro-RU Adarian politicians served its purpose of facilitating Adarians' integration to the Russian Union. Moreover, these contributions did not violate Adaria's domestic laws. Section 17.1031 of the Adarian Civil Code only prohibits political contributions from a foreign business or a corporate entity, and the Russian Union legation is neither one nor the other, but as recognized as the Adarian's own prime minister, it is the representative of the Russian Union in Adaria. As the Russian Union legation was properly fulfilling its functions at all times while in Adaria, it was entitled to functional immunity. The importance is that Adaria violated the Russian Union legation's functional immunity by seizing its premises, property, and personnel. International law accords the property and archives of international organizations very broad protection. In Shearson Lalunin Brothers, Inc. versus International Tin Council, the British House of Lords held that the ITC had the same immunity for its archives as did diplomatic missions. The Vienna Convention on Diplomatic Relations provides that the documents of such missions shall be inviolable at any time wherever they be. The House of Lords in Shearson also clarified that archives includes all documents belonging to or held by the organization. Adari's seizure of the Russian Union legation's bank records, as well as other files, clearly violated this immunity. The personnel and premises of an international organization also enjoy broad protection under international law. For example, in 767 3rd Avenue Association versus Permanent Mission of SARE, the United States Second Circuit of Court of Appeals found that the landlord could not forcibly enter the premises of the SARE mission to evict its tenants for failure to pay rent, even though the landlord owned the building. In this case, Adarian only stormed the Russian Union without warning and without seeking its content. But it also arrested Ambassador Heap and imprisoned him for 2 days without filing any official charges. This blatant disrespect of the Russian Union's premises and its personnel should not be tolerated by the court. As a fourth point, Adari's National Industry Act, NIA, illegally expropriated assets owned by respondents' nationals. The NIA constitutes an expropriation of assets owned by the respondent citizens. Expropriation is not limited to a state's direct taking of assets, but also encompasses any unreasonable interference with the use, enjoyment, or disposal of property so as to justify an interference that the owner thereof will not be able to use, enjoy, or dispose of the property within a reasonable period of time after the inception of such interference. In Started Housing Corporation versus Iran, the Iran United States Claims Tribunal found that expropriation includes any interference with property rights which renders those rights useless to the owner. Indeed, any covert or incidental interference with the use of property which deprives the owner of the economic benefits of his property, even if not to the obvious benefits of the states, is expropriation. To determine whether a governmental action is expropriation, tribunals generally consider the degree of interference with the property rights as a first step, the purpose and context of the governmental measures as a second step, and third, the interference of the measure with reasonable and investment-backed expectations. Interference with property ownership, which substantially impairs the owner's use or enjoyment of the property, has consistently been found to be expropriation. In the Revere Copper and Brass Inc. versus OPIC, the tribunal held that Jamaica's decision to charge the applicant increased royalties was an expropriation. The tribunal reasoned that even though the applicant still had legal title to its property and was still able to operate its business, the governmental actions had effectively deprived the applicant of the right to control and use its property. Similarly, in CME, the Netherlands versus Czech Republic, the tribunal found that Czech National Media Council's restrictions on the use of an exclusive license granted to the applicant's media company constituted an expropriation because the restrictions destroyed the applicant's operations, leaving the company with assets but without business. The NIA similarly deprives the respondents' nationals from using and enjoying their property, their investments in an area, like the exorbitant increase in royalties in Revere Copper, which prevented applicants from deriving financial benefit from his business in Jamaica, the NIA's absolute ban on capital transfers prevents companies based in the Russian Union from utilizing the profit of the Adarian enterprises. Moreover, just as the license restrictions in CME technically left the applicants with ownership of their assets but without a use for them, the NIA prevents the Russian Union Corporation from enjoying the integration benefits of their ownership of the formerly Adarian-run enterprises. Thus, Adaria has, for all effective purposes, taken the property of respondents' nationals. While governments occasionally pass regulations which affect foreign interests without amounting to expropriation, the cases in which tribunals have upheld such action involved laws which granted property owners much greater freedom to manage their assets than those the NIA. For instance, in Pope and Talbot Inc. versus Canada, the tribunal upheld regulation which introduced export quotas that resulted merely in a reduction of profits. In contrast, the NIA totally deprives the Russian Union corporations of the use of their profit made in Adaria. In starred housing, the detention of applicants' personnel which the tribunal upheld did not amount to a taking of property because it did not completely deprive the asset owners of the right and ability to utilize and profit from their assets. The NIA, on the other hand, leaves no such residual right to the Russian Union-based corporations, but rather absolutely prohibits the export of profits. At last, the NIA's expropriation of respondents' nationals' assets is illegal because it is discriminatory and does not provide for compensation. As the United Nations resolutions on permanent sovereignty over natural resources resolution, has been widely acknowledged by arbitral tribunals and publicists as reflecting customary international law, it provides the appropriate standards by which to judge whether expropriation is legitimate. According to the resolution, expropriation can be justified only if it is 1. For a public purpose, 2. Provided for by law, 3. Non-discriminatory, and 4. Accompanied by adequate compensation. All 4 conditions must be met. As the NIA does not satisfy this condition, it is illegal. Discriminatory expropriation is illegal. In Anuco International Finance Corporation versus Iran, the Iran-United States Claims Tribunal held that customary international law prohibits discriminatory expropriation when there is not an objective and reasonable justification for the decision made. The American Restatement of the Law of Foreign Relations provides that a governmental act is discriminatory if it is applied only to alien enterprises. Expropriation is also discriminatory if it is engaged in for extraneous political reasons. Thus, in British Petroleum Exploration Company versus Libya, the arbitrator found Libya's nationalization law to be discriminatory because it was an act of political retaliation against Britain. Just as the nationalization in the British Petroleum case was targeted as a specific company, the NIA effectively applies only to business concerns owned by Russian Union-based corporations. While the NIA refers to recently privatized business concerns, all such business concerns were privatized and purchased by companies based with the Russian Union. Furthermore, like the politically retaliatory law in the British Petroleum case, which was designed to expel the British from Libya, the NIA was meant to punish the Russian Union for its decision to postpone Adaria's admission. The Adarian Parliament passed the NIA shortly after its unsuccessful bid for the Russian Union membership and within days of Ambassador Sip's arrest. The effect of the NIA has also been to encourage the Russian Union-based corporations to leave Adaria. In this aspect alone, the NIA is illegal. Expropriation without prompt, adequate, and effective compensation is also illegal. The requirement to compensate is universally accepted and is provided for in the Resources Resolution, as well as in the Charter of Economic Rights and Duties of States. National laws have also consistently found compensation to be decisive in determining whether government takings are illegal. In Libyan American Oil Corporation versus Libya, the arbitrator found that the Libyan government had an obligation to compensate the applicant for concession rights, which it had nationalized. Similarly, the arbitral tribunal in Benevetti versus Kondo ordered the Congolese government to compensate the applicants for nationalizing business concerns in which they had an interest. Adaria has not provided any compensation to the Russian Union companies. In this regard, the NIA is patiently illegal. For the conclusion of the defendants of the respondents, it is important to establish the prayers for relief. For the foregoing reasons, respondents respectively request the Honorable Court to find, adjudge, and declare as follows. 1. The denial of Adaria's application to join the Russian Union did not breach any international or legal obligations owed to Adaria by respondents. 2. That respondents may properly bring a claim for Adaria's actions against the Russian Union legation, its property, and Ambassador Heap. 3. That Adaria violated international law concerning the immunity of diplomatic missions by seizing the premises, property, and personnel of the Russian Union. And 4. That the National Industry Act constitutes an illegal expropriation of respondents' national property.